Welcome to the second section of the lecture. And we'll move forward with the slides here. The requirements of subsection 4 do not apply to a firearm if there are not any bids from eligible persons received within 6 months from when bidding opened on the firearm, or if the agency director, sheriff, chief of police, or a designee of the official certifies that the firearm is unsafe for use because of wear, damage, age, or modification, or because any federal or state law prohibits the sale or distribution of the firearm. The agency director, sheriff, chief of police, or a designee of the official may transfer any of these firearms to the Attorney General's crime laboratory for training or experimental purposes, or to a museum or historical society that displays these items to the public and is lawfully eligible to receive the firearm, or the firearm may be destroyed. The requirements of subsection 4 do not apply to a firearm, and an agency, director, sheriff, chief of police, or a designee of the official may destroy the firearm if 1. The firearm was used in a violent crime, in an accidental shooting, or a self-inflicted shooting resulting in the death of an individual. 2. There is not a claim for the firearm by an innocent owner. And 3. A family member of the deceased individual makes a written request for the destruction of the firearm. B. Agencies subject to the provisions of this subsection may establish a procedure to destroy firearms and may expend necessary funds for that purpose. All agencies subject to the provisions of this section shall keep records of the firearms acquired and disposed of as provided in this section, as well as the proceeds of the sales and the disbursement of the proceeds, and shall maintain these records for not less than 10 years from the date on which a firearm is disposed of or on which a disbursement of funds is made, as the case may be. Neither the state, nor any political subdivision of the state, nor any of their officers, agents, and employees is liable to any person, including the purchaser of a firearm, for personal injuries or damage to property arising from the sale or disposal of a firearm under subsection 4 or 5 of this section unless an officer, agent, or employee of the state or political subdivision acted with gross negligence or recklessness. As used in this section, the term innocent owner means a person who a. did not beforehand know, or in the exercise of ordinary care would not have known of the conduct which caused that person's firearm to be forfeited, seized, or abandoned to any law enforcement agency of the state or any political subdivision of the state, including the Game and Fish Department. B. Did not participate in the commission of a crime or delinquent act involving that person's firearm. C. Legally owned and presently owns the firearm forfeited, seized, or abandoned. And D. Is authorized by state and federal law to receive and possess his or her firearm. Okay, now I know most of that didn't have anything to do with carrying a concealed weapon, but we made it through, so congratulations. Now we're going to get to, this is something that's pretty important here. This is a limitation on authority of political subdivision regarding firearms. So political subdivision, including home rule cities or counties, may not enact any ordinance relating to the purchase, sale, ownership, possession, transfer of ownership, registration, or licensure of firearms and ammunition, which is more restrictive than state law. All such existing ordinances are void. So this is considered a state preemption statute, so that anywhere within the state cannot enact laws that are more restrictive in those categories relating to firearms. As used in this section, firearm buyback program means a program to purchase privately owned firearms, firearm parts, or ammunition from private individuals or organizations for the purpose of providing cash, gifts, or vouchers, or reducing the number of firearms, firearm parts, or ammunition owned by civilians, or permitting a civilian to sell a firearm to the government without fear of prosecution. The term does not include the purchase of firearms, firearm parts, or ammunition from a licensed firearm dealer, or a program to purchase firearms, firearm parts, or ammunition for law enforcement purposes. So this is prohibiting buyback programs. A state agency, political subdivision, or any law enforcement agency of the state may not conduct a firearm buyback program or participate in the implementation, administration, or operation of a firearm buyback program. A state agency, political subdivision, or any law enforcement agency of the state may not expend any taxpayer dollars for the purpose of implementing, administering, or otherwise operating a firearm buyback program. A violation of this section is a Class A misdemeanor. I do realize that each of you taking this class is neither a state agency, political subdivision, or law enforcement agency. So I think this is for informational purposes. Now, possession of weapons. This is more related to actually possessing weapons. Persons who are not to possess firearms. Penalty. A person who has been convicted anywhere of a felony offense involving violence or intimidation in violation of chapters 12.1-16 through 12.1-25, or an equivalent felony offense of another state or the federal government is prohibited from owning a firearm or having one in possession or under control from the date of conviction and continuing for a period of 10 years after the date of conviction or the date of release from incarceration, parole, or probation, whichever is latest. A person who has been convicted anywhere of a felony offense of this or another state or the federal government not provided for in subdivision A, or who has been convicted of a Class A misdemeanor offense involving violence or intimidation in violation of chapters 12.1-16 through 12.1-25, or an equivalent offense of another state or the federal government, and the offense was committed while using or possessing a firearm, a dangerous weapon, or as defined in section 12.1-104, a destructive device or an explosive, is prohibited from owning a firearm or having one in possession or under control from the date of conviction and continuing for a period of 5 years after the date of conviction or the date of release from incarceration, parole, or probation, whichever is latest. A person who is or has ever been diagnosed and confined or committed to a hospital or other institution in this state or elsewhere by a court of competent jurisdiction other than a person who has had the petition that provided the basis for the diagnosis, confinement, or commitment dismissed under those sections, or equivalent statutes of another jurisdiction as a person requiring treatment as defined in section 2503.1-02, or as a mentally deficient individual is prohibited from purchasing a firearm or having one in possession or under control. This limitation does not apply to a person who has not suffered from the disability for the previous 3 years or who has successfully petitioned for relief under that following section. Continuing on with people who are not to possess firearms in the state. A person under the age of 18 years may not possess a handgun, except that such a person, while under the direct supervision of an adult, may possess a handgun for the purposes of firearm safety training, target shooting, or hunting. A person who violates subdivision A or B is guilty of a Class C felony, and a person who violates subdivision C or D is guilty of a Class A misdemeanor. For the purposes of this section, conviction means a determination that the person committed one of the above-mentioned crimes upon a verdict of guilt, a plea of guilty, or a plea of nolo contendere. It means no contest in Latin, even though the court suspended execution of a sentence in accordance with subsection 3 of this section listed. The court deferred imposition of sentence in accordance with subsection 4 of section that one. The court placed the person on probation, or the person's conviction has been reduced in accordance with subsection 9 of section, and you see the sections there in chapter 12. Sentence dispositions, sentence reductions, or offense determinations equivalent to this section were imposed or granted by a court, board, agency, or law of another state or the federal government, or the person committed an offense equivalent to an offense described in subdivision A or B of subsection 1 when that person was subject to juvenile adjudication or proceedings in a determination of a court under chapter 27-20 or of a court of another state or the federal government was made that the person committed the delinquent act or offense. A felon who is not sentenced under section 12.1-32-09.1 may possess a rifle that has a barrel 16 inches or longer, or a shotgun that has a barrel 18 inches or longer, and which is one of the following. A firearm, including any firearm with a matchlock, flintlock, percussion cap, or similar type of ignition system manufactured before 1899. B, a replica of any firearm described in Subdivision A if the replica is not designed or redesigned for using rimfire or conventional centerfire fixed ammunition, or uses rimfire and conventional centerfire fixed ammunition that is no longer manufactured in the United States and which is not readily available in the ordinary channels of commercial trade. C, a muzzle-loading rifle or muzzle-loading shotgun designed to use black powder or a black powder substitute and which cannot use fixed ammunition. Okay, restoration of right to possess a firearm. Obviously, if you guys are in this class, hopefully you're eligible to possess a firearm and you aren't concerned with the legal process for restoring that right, but this is provided for informational purposes. An individual prohibited from possessing a firearm due to a conviction of a felony under Subdivision B or Subsection 1 of Section 62.1-02-01 may petition the District Court for restoration of the individual's firearm rights. If the felony offense was committed in this state, the petition must be filed with the District Court in the county where the offense occurred. If the offense was a felony of another state or the federal government, the petition must be filed in the venue where the rights of the individual were revoked. A copy of the petition must be served on the state's attorney's office in the county where the petition is filed in accordance with Rule 5 of the North Dakota Rules of Civil Procedure. The state's attorney's office has 20 days to file a written response to the petition with the district court. The district court may restore the right of an individual to possess a firearm if the court determines by clear and convincing evidence that all of the following circumstances exist. A, the individual has paid all fines imposed for the violation resulting in the prohibition. B, the individual has served all terms of imprisonment imposed for the violation resulting in the prohibition. C, the individual has successfully completed all conditions of probation or parole imposed for the violation resulting in the prohibition. And D, the individual's record and reputation are such that the individual is not likely to act in a manner dangerous to the safety of others. Mental disability in the possession of firearms. A court shall make a finding as to whether the provisions of 18 U.S. Code 922D4 and G4 apply to the subject of a following proceeding in which the court A, finds that a person, as a result of mental disease or defect, may not be held criminally responsible in any case pursuant to those chapters. B, finds that a person is a mentally deficient individual. C, orders involuntary hospitalization or commitment to a treatment facility or involuntary treatment pursuant to Chapter 25-03.1. D, orders involuntary commitment or involuntary treatment under Chapter 2503.3. E, appoints a guardian ad litem under Section 2803.04. F, appoints a guardian under Chapter 30.1-28, or G, appoints a conservator under Chapter 30.1-29. If the court finds that the provisions apply, the clerk of the court shall forward the individual's name and non-clinical identifying information to the Bureau of Criminal Investigation, which shall forward the information to the Federal Bureau of Investigation or its successor agency for inclusion in the National Instant Criminal Background Check System database. The court also shall notify the individual of the prohibitions of the 18 U.S. Code and, if relevant, of Subdivision C of Subsection 1 of Section 62.1-0201. If a court of this state has found an individual under Subsection 1 to be subject to the provisions in that U.S. Code, that individual may petition the court that issued the findings or the district court of the county where the individual resides to remove that individual's firearms-related disabilities, as provided in Public Law Number 110-180, 105A. A copy of the petition for relief must be served on the director of the treatment facility that treated the individual pursuant to court order, and the prosecuting attorney of the county in which the original finding, order, or appointment occurred. The director of the treatment facility that treated the individual pursuant to court order and the prosecuting attorney may appear, support, object to, and present evidence relevant to the relief sought by the petitioner. The court shall receive and consider evidence in a closed proceeding, including evidence offered by the petitioner concerning a. the circumstances of the original order, appointment, or finding, b. the petitioner's mental health and criminal history records, if any, c. the petitioner's reputation, and d. changes in the petitioner's condition or circumstances relevant to the relief sought. 4. The court shall grant the petition for relief if the court finds by preponderance of the evidence that the petitioner likely will not act in a manner dangerous to public safety, and that the granting of the relief would not be contrary to the public interest. A record must be kept of the proceedings. The record is confidential and may be disclosed only to a court in the event of an appeal. An individual may file a petition for relief under this section no more than once every 2 years. When a magistrate or court issues an order granting a petition for relief under subsection 3, the clerk of the court immediately shall forward a copy of the order to the Bureau of Criminal Investigation in the format and medium specified by the Bureau after consultation with the state court administrator. The Bureau immediately shall forward a copy to the Federal Bureau of Investigation or its successor agency for updating of the National Instant Criminal Background Check System database. All right, now we're done with that. So moving on. Sale of a handgun regulated. This is maybe more relevant, potentially. No person may transfer a handgun to any person who the transferor knows or has reasonable cause to believe is a person prohibited by Section 62.1-02-01 from possessing a firearm. Any person who violates this section is guilty of a Class A misdemeanor. So if you know or have reasonable cause to believe that somebody is a prohibited possessor, you may not give them or sell them a gun. A person who possesses, obtains, receives, sells, or uses a short-barrel rifle or a short-barrel shotgun is guilty of a Class C felony. This section does not apply to law enforcement officer who possesses, obtains, receives, sells, or uses a short-barreled rifle or a short-barreled shotgun in the course of or in connection with the officer's official duties, to a member of the Armed Forces of the United States or National Guard, organized reserves, state defense forces, or state guard organizations, who possesses or uses a short-barreled rifle or short-barreled shotgun issued to the member by that organization and while on official duty, or to any person who complies with the National Firearms Act. Okay, so this is about possessing a firearm or dangerous weapon in a liquor establishment. An individual who enters or remains in that part of the establishment set aside for the retail sale of alcoholic beverages and the consumption of purchased alcoholic beverages or used as a gaming site at which bingo is the primary gaming activity, while that individual knowingly possesses a firearm or dangerous weapon, is guilty of an infraction. In addition, an individual is guilty of an offense under this section for the knowing possession of a device that uses a projectile and voltage, or a device that uses a projectile and may be used to apply multiple applications of voltage during a single incident in the part of an establishment set aside for the retail sale and consumption of alcoholic beverages. Just an aside, you may notice certain restaurants or bar type places that serve food and alcohol have liquor licenses. Sometimes there's actually a section of the restaurant that's set aside that is not for the alcohol, where you don't have to be 21, and then there's other areas where you do have to be 21 to be in there where the alcohol is served. And so just keep that in mind, which part you're in as far as what would apply to you here. Okay, this section does not apply to the restaurant, bar, carry type of thing. Does not apply to a law enforcement officer, the proprietor's employee, designee of the proprietor when the designee is displaying an unloaded firearm or dangerous weapon as a prize or sale item in a raffle or auction. Doesn't apply to private security personnel while on duty for the purpose of delivering or receiving monies used at the liquor establishment or at the gaming site at which bingo is the primary gaming activity. The restaurant part of an establishment, if an individual under 21 years of age is not prohibited in that part of the establishment. So it doesn't apply if you can take your kids with you and your kids are under 21. An individual who knowingly possesses a firearm, I'm just going to back up for a second. This is the public gathering one. This is very important to understand that the definitions are what they are. They say what they say. They mean what they mean. And so this one gets confused sometimes by people in the public when they apply their own understanding of the definitions rather than using the definitions that the law provides. So, an individual who knowingly possesses a firearm or dangerous weapon at a public gathering is guilty of an infraction. What does that mean? Well, for the purpose of this section, public gathering means an athletic or sporting event, a school, a church or other place of worship, and a publicly owned or operated building. That's what a public gathering is. Now, this section does not apply to a law enforcement officer or a correctional officer employed by the Department of Corrections and Rehabilitation or by a correctional facility governed by that chapter. A correctional officer employed by the Department of Corrections and Rehabilitation may carry a firearm only as authorized in Section 1247-34. A correctional officer employed by a correctional facility governed by Chapter 12-44.1 may carry a firearm or dangerous weapon only as authorized in Section 12-44.1-30. Okay, here's further people who go back. This section does not apply to a member of the Armed Forces of the United States or National Guard, Organized Reserve, State Defense Forces, or State Guard organizations when on duty. A competitor participating in an organized sport shooting event, a gun or antique show, a participant using a blank cartridge firearm at a sporting or theatrical event, a firearm or dangerous weapon carried in a temporary residence or motor vehicle, a student and an instructor at a hunter safety class, private and public security personnel while on duty, a state or federal park. An instructor, a test administrator, an official, or a participant in educational, training, cultural, or competitive events involving the authorized use of a dangerous weapon if the event occurs with permission of the person or entity with authority over the function or premises in question. An individual in a publicly owned or operated rest area or restroom. We're still going through, this section does not apply to. An individual possessing a valid concealed weapons license from the state or who has reciprocity under Section 62.10403.1, authorizing the individual to carry a firearm or dangerous weapon concealed if the individual is in a church building or other place of worship and has the approval to carry in the church building or other place of worship by a primary religious leader of the church or other place of worship or the governing body of the church or other place of worship. A state, federal, or municipal court judge, district court magistrate judge, or judicial referee, and a staff member of the Office of Attorney General if the individual maintains the same level of firearms proficiency as is required by the Peace Officer Standards and Training Board for Law Enforcement Officers. A local law enforcement agency shall issue a certificate of compliance under this section to an individual who is proficient. An individual's storage of a firearm or dangerous weapon in a building that is owned or managed by the state or political subdivision provided 1. The individual resides in the building. 2. The storage is inside the individual's assigned residential unit. And 3. The storage has been consented to by the state, the governing board, or designee, and an individual authorized to carry a concealed weapon on school property under Section 62.1-02-14. This section does not prevent any political subdivision from enacting an ordinance that is less restrictive than this section relating to the possession of firearms or dangerous weapons at a public gathering. An enacted ordinance supersedes this section within the jurisdiction of the political subdivision. So they can lighten the law, but they can't be more restrictive than state law. Notwithstanding any other provision of law, a church or place of worship may not be held liable for any injury or death or damage to property caused by an individual permitted to carry a dangerous weapon concealed under this section. This section does not prevent the governing body of a school or the entity exercising control over a publicly owned or operating building or property from authorizing the use of a less than lethal weapon as part of the security plan for the school, building, or property. Okay, new thing. Discharge a firearm within the city. Generally don't do that. A person who discharges a firearm within a city is guilty of a Class B misdemeanor. This section does not apply to the lawful discharge of firearms by law enforcement officers, by citizens in defense of person or property, or by participants in lawful activities, in which discharge of firearms is a recognized part of the activity, including shooting galleries and ranges. Okay, use of firearms by certain minors prohibited. Any parent, guardian, or other person authorized by the parent or guardian of any minor under 15 years of age, under 15, who permits that minor to carry or use any firearm of any description loaded with powder and projectile in public is guilty of a Class B misdemeanor. This section does not apply if the minor is under the direct supervision of the parent, guardian, or other person authorized by the parent or guardian. So you have to be 15 to have a loaded gun in public, not under direct supervision. Seems to be what that says. Now remember, in relation to handguns, it wouldn't be able to be a handgun. So you have to be 18 to have a handgun by yourself. Okay, illegal firearms, ammunition, or explosive materials business. I'm wondering, are any of you involved in that? A person is guilty of an offense if the person supplies a firearm, ammunition, or explosive material to, or procures or receives a firearm, ammunition, or explosive material for a person prohibited by this title from receiving it, if the transferor knows or has reasonable cause to believe that such person is prohibited by section 62.1-02-01 from receiving or possessing it. Okay, so you can't get firearms or ammunition or bombs for prohibited persons. That makes you a criminal as well. The offense is a Class C felony if the actor A was not licensed or otherwise authorized by law to handle, transfer, or engage in transactions with respect to the firearm, destructive device, or explosive material, or B, engaged in the forbidden transaction under circumstances manifesting the actor's readiness to supply or procure on other occasions in disregard of lawful restrictions. Otherwise, the offense is a Class A misdemeanor. Okay, possession of explosive or destructive device in government building. Again, that's a no-no. A person, except for a law enforcement officer while in official business, is guilty of a Class C felony if the person possesses an explosive or destructive device in the government building without the written consent of the government agency or person responsible for the management of the building. Don't bring bombs or destructive devices into the government buildings, please. Okay, carrying loaded firearm in certain vehicles prohibited. Now this is a little bit more relevant to people in this class. An individual may not keep or carry a loaded firearm in or on any motor vehicle, including an off-highway vehicle or snowmobile in this state. An individual violating this section is guilty of an infraction. This prohibition does not apply to 1. A member of the Armed Forces of the United States or National Guard, organized reserve, state defense forces, or state guard organizations while possessing the firearm issued to the member by that organization and while on official duty. It does not apply to a law enforcement officer or an individual possessing a valid concealed weapons license from this state or who has reciprocity under section 62.1-04-03.1 with a handgun or with a rifle or shotgun if not in the field hunting or trapping. So there's a distinction there between carrying a handgun concealed versus somebody who has a rifle or shotgun when you're hunting or trapping. It Does not apply to an individual in the field engaged in lawful hunting or trapping of non-game species or fur-bearing animals. It does not apply to a security guard or private investigator properly licensed to carry firearms, or to an individual possessing a valid special permit issued pursuant to sections 20.1-02-05. That's a special permit by Game and Fish. Or doesn't apply to an individual who is not otherwise precluded from possessing a Class 2 firearm and dangerous weapon license under 62.1-04, and who has possessed for at least 1 year a valid driver's license or non-driver identification card issued by the Department of Transportation. In other words, this is what people tend to refer to as constitutional carry. So if you have North Dakota driver's license or non-driver identification card issued by the Department of Transportation, you've had it for a year, and you're otherwise not precluded from having a Class 2 license, even though you don't have one, it would not apply to you. Okay, an individual who is in the field engaged in lawful hunting of big game or small game and who violates section 62.1-02-10 is not subject to a criminal penalty, but is guilty of a Class 2 non-criminal offense under Chapter 20.1-01. So the whole thing about being in the field, and if you look at number 3 here, where it talks about or with a rifle or shotgun if not in the field hunting or trapping, and you go to this section here. So if you are in the field and you're hunting big game or small game and you violate that section about the motor vehicles, it's a Class 2 non-criminal offense. Okay, possessing explosives prohibited. This might not be too relevant to this, other than it does talk about dangerous weapons. No person may have in custody, possession, or control any nitroglycerin, dynamite, or any other dangerous or violent explosive unless the explosive is carried in the prosecution of or to effect a lawful and legitimate purpose. Any person violating this section is guilty of a Class C felony.